Fill the halls. Welcome to folks watching online. We're streaming this live online. My name is Andrew Mead. I'm the Senior Associate Justice of the Maine Supreme Judicial Court. Ordinarily, Chief Justice Stanfill would be seated here and conducting these proceedings, presiding over them, but she has, as I've been saying, been hit by a bulldozer of a cold and a virus, but she's very much part of this panel. She'll be participating in the decision process. She's either listening now or will be listening to the recording later. We also have one recusal and a vacancy, so the panel for this case will be us plus the Chief Justice. Want to say a few words before we get underway. First is to welcome the students who are joining us here today. And I have some recognitions I'd like to pass on. This is, for those of you who don't know, this is part of our October, what we call the high school road trip. These are cases that we present at high schools around the state at the invitation of state representatives. I'd like to, if any of these folks are present, if you please just stand or give us a wave. I'd like to recognize Senator Peggy Rotundo. She was one of the key players here. She's actually at the legislature voting on judicial nominations today, so we certainly said to her we understand and support that. Also, Representative Kristen Cloutier was present earlier, but she also had other matters to attend to. Representative Margaret Craven is present, giving us a wave. Representative Mana Abdi, I believe she also had another obligation to attend to. Also want to express our thanks to Jonathan Radke, who is the principal here, for putting this together. We're grateful for that. Special thanks to Representative Adam Lee, who is present. He's also a member of the legislature, a member of the Judiciary Committee, also the lawyer of the day who is helping organize and facilitate these proceedings. Also recognize Doug Dumont, who is the assistant principal here today. And as always, recognizing the custodial staff, the AV setup. As I've said before, the auditorium setup, which was set by the Lewiston Blue Devils football team. As I said before, if their precision in their playmaking matches the precision they've set up here, they should be in good shape. So we're ready to get underway with this proceeding here today. Ordinarily, I would ask the attorneys to stand and indicate who they are representing, but given the numbers we're dealing with here today, I'll ask anyone who will be arguing here today, please give us your name at the outset, and we can save some time going forward. That being said, I believe we are in order to proceed. We'll call the case. This is Cumberland 24-82, Peter Masucci et al. Versus Judy's Moody, LLC et al. And you have prepared a list of presentations. We've coordinated with you. And I believe, Attorney Richard, you are first up. Is that correct?
That's correct, Your Honor.
All right. We'd be happy to hear your arguments then.
Keith Richard of Archipelago on behalf of the appellants Masucci et al. May it please the court. This is a case to restore the public's rights on intertidal land. Bell versus Town of Wells was the first case in Maine history that held that public access for a particular purpose was prohibited. In every single prior decision, whenever the issue was whether someone had the right to cross over, enter, remain on intertidal land without taking or leaving anything, the court sided with the public over the private owner. Bell must be conclusively overruled now, not merely because it was wrong, but because it was jarringly out of step and anomaly at the time it was decided, and it's been criticized in each case since. Eaton, McGarvey, Ross have been incremental steps to correcting the error, all leading here. To end the acrimony, chaos, and conflict, we ask, legalize reasonable recreational use of the intertidal zone. We have presented the court with multiple grounds to get there. Recreation is legal, both because the common law allows it and because the legislature by statute said so. And in so doing did not commit an unconstitutional taking. That was a perfectly permissible exercise of the state's police power to say what the public trust is. Bell's holding otherwise was clearly wrong, but it appears to be the only reported precedential decision holding that a statute defining public trust rights was an unconstitutional taking. And if there's another case out there, appellees here haven't cited it. The state always has the power to define public trust, even if intertidal land can be privately owned. There is no such thing as unqualified fee title ownership of public trust land. And at bottom, we're asking the court to let other branches of government, let municipalities have a say. In taking a step back, this court can return to just deciding cases, whether a user is unreasonably interfering with a private owner's rights, rather than making policy. And it's worth emphasizing that our opponents in this case rely on per se, automatic rules, that a use is per se not allowed, that a shift in the law is per se a taking because they must. There's no good argument for their position if the court correctly applies the reasonableness or balancing standards that apply to those issues. Almost everyone believes in these public rights, and only a few of the very few who own waterfront property want to retain the right to exclude, and their view is extreme. They read Bell to give them a private beach, and their signs say so. We ask this court to fix this imbalance of public and private rights that Bell created. I'm ready for questions.
All right, we'll turn the green light on it. Just to get started, we have so much to talk about here today, not a whole lot of time. But I want to start off the conversation with the issue of justiciability standing. And as we know, some of the defendants put up signs. And I'll talk about the non-business plaintiffs here. Put up some signs, no loitering, etc. In order to have standing, there must be a live controversy. And it has been suggested that perhaps there isn't a live controversy because people continue to walk and traverse the intertidal area, and that the plaintiffs have ginned up standing by sort of created this controversy because they are now, their walking opportunities have been impacted by the fact that they're stressed out by the fact that it may result in a conflict. Is that enough to get past the gates of standing and justiciability?
That is a particularized injury, Your Honor. The trial court found that there was standing in this case because several plaintiffs are actual users of Moody Beach. They have seen the signs. The signs have affected their experience of accessing Moody Beach, which is a public resource as to the intertidal zone.
Have any of them actually trod upon the areas past the signs?
They have, and the summary judgment record reflects that.
And was there any conflict or concern or adverse effect to them if, in fact, they did that?
The summary judgment record, and I point Your Honors to the appendix at 837 to 859, and specifically to 838 to 843, establishes that the plaintiffs that the trial court found had standing have established a record that they have felt that.
So just to be clear, since you're on top of the record, so they walked onto the property and the beach owner said, they said to the beach owner, I want to do X on your property, and the beach owner said, no, you may not, get off my property. Is that the record?
The record is that the sign says that Moody Beach is a private beach to the low water mark.
Correct. And
So where
no
is it?
loitering, correct?
Correct.
And they felt chilled by that, correct?
It doesn't say welcome fishers, fowlers, and navigators.
So they have standing as long as it doesn't say welcome?
Their injury is the adverse experience of accessing Moody Beach, and that their enjoyment of that area is affected by it negatively, and that they would otherwise engage in activities that they don't because of the chilling effect.
Well, I understand that there's one plaintiff, Gilbert, correct, who wanted to harvest rockweed, and he was rebuffed, correct?
As to the seaweed issues, I'm
Right.
talking about Moody Beach.
Well, we'll get there. As to the seaweed issue, and so he was rebuffed, and that he tried to do something he didn't. He had standing. Here's something you'll disagree with, my hypo, but if he's the only one who had standing, can he argue all the claims, or is he limited to only arguing about rockweed? Because if we only have to find one person has standing, but they're able to argue absolutely everything, then we don't have to figure out which ones have standing and which don't.
I think Mr. Gilbert there is in the summary judgment record that he recreated on the intertidal zone. But as to that hypothetical, I would agree with you, Your Honor. But we do, as to the Moody Beach plaintiffs, have a record that establishes all these uses, specifically Peter Masucci, Kathy Masucci, and William Canerney, that raise recreation generally.
Can I ask you just a procedural question? Have the plaintiffs' counsel agreed to divide up particular subject matters during your during your arguments, or is it fair game for all of it?
Fair game for all.
Okay.
All right, well, then I'll go on to another topic. When it comes to the issue of title ownership, okay, because you're making two basic arguments. One is they don't own it, and the other one is if they own it, they're subject to a sympathetically generous fish fouling and navigating, and broadly construed. So let's focus on ownership, title ownership. It's pretty clear in Bell that the ownership decision was made, and you say it was incorrectly made. How, if we agreed with you, how can we change the law after the Supreme Court's decision in Stop the Beach Renourishment, which says after a court has established title, if you take it away by a new decision, that's an unconstitutional taking under the U.S. Constitution?
Public trust land is different. Stop the Beach Nourishment is not a public trust case.
Why is that different?
Because public trust land is incapable of alienation by the state. It's always held in trust by the public, by the state.
Under what law?
Under U.S. Supreme Court law and under state law.
Well,
In order to give your clients the remedy they're seeking here, do we have to throw Bell in the dustbin?
Say that again?
In order to give your clients the relief they're looking for here, do we have to give Bell the heave-ho?
I think that Bell is hobbling and it deserves a proper burial.
Okay, all right.
Regarding standing, I take it your client's position is they want to be able to loiter, as the signs indicate, on the beach. And this would be analogous to a Fitzgerald plaintiff driving up to Baxter State Park and finding a sign saying no loitering, no camping, something of that nature, I take it.
So the issue of a public user of a publicly available resource and then whether the signage is a justiciable controversy, I see those as separate. The more recent case is Black, and in that case, unlike Fitzgerald, we were looking, it wasn't that the AG was disabled, they were actual users of the resource, and those arguments were made. I think signage is enough to make a justiciable controversy. There's over 400 pages of briefing that suggest that this controversy is very much a controversy. So I think that if the defendants if they agreed, okay, well, if you would like to engage in whatever recreational use there is, we don't object, we take down the signs, that's a different case.
Are your clients in the same circumstance as the plaintiffs in the Fitzgerald case?
Well, it's not about the Baxter State Trust and a breach of a trust document. We're more like the public lands in Black.
Okay, so you say Fitzgerald doesn't control?
I think that Black is the more analogous case. Fitzgerald is a foundational standing case in Maine, and it is about public access to a publicly available park, there, Baxter State Park. But I think Black is the more recent applicable authority.
Okay, all right. I'm going to do for you what I'm going to do, frankly, for everybody. I'm going to give you maybe 30 seconds. If there's something you wanted to say coming to the lectern that you weren't able to say, take 30 seconds.
I want to address the seaweed issue, Your Honor, because I think that with the benefit of the common law and of the statute from 1820, of the legislature's statement of DMR's regulation, there is no way that Ross can survive. And it is an example of why the common law system of making policy, when you don't have all the information, is not a good way to make policy.
Thank you.
Justice Mead, may I ask a question?
Certainly. I guess we have another question.
Sorry, just a second.
Thank you. You're making the argument here that the beachfront owners do not have title, that Bell was incorrectly decided. Is that right?
Correct.
And what's the basis for that?
Bell-
No, go ahead.
Bell misconstrued Article 10 of the Maine Constitution and misconstrued Lappish and all the cases that follow it to mean that Maine properly alienated title to intertidal land, when the U.S. Supreme Court in every case says that upon statehood, a state takes title to intertidal land.
How do you reconcile that position with the Eaton case and with the Almeida case? In both of those cases, title to a particular lot on the beach was traced back to essentially Charles I. So if it's the case that the Crown properly conveyed property to proprietors, and proprietors properly conveyed property, the interest in that property to an owner, and that deed chain carries all the way to the present. How is that not a property right? How is that not a vested right, regardless of the fact that the state of Maine came into existence in 1820?
Read the U.S. Supreme Court cases. Equal footing doctrine voids everything that came before it at state.
Well, what does the equal footing doctrine actually say? It says that the incoming state, the new states, take the rights of the original 13, right? They're on the same footing.
Correct.
But the original 13 weren't on the same footing. And Shively specifically recognized that Massachusetts was in a different place than Virginia or Delaware or North Carolina. And it specifically recognized that the Massachusetts law said that those property owners had a vested right in the property.
Massachusetts law cannot control another state's assumption of title pursuant to equal footing as a matter of federal constitutional law. Federal constitutional law is supreme to any parent state's property law or to any other principle.
But the Due Process Clause is also federal constitutional law. So how do you reconcile equal footing with the 14th and 5th
Because
Amendments?
it vests title in the government. You can't adversely possess property against the government. Property that goes to the government is different. It's not ordinary private property.
Thank you.
All right, thank you. Professor? Would you please state your name for the record?
May it please the court, my name is Orlando DeLogue. I'm a plaintiff pro se in these proceedings. I would begin by simply saying that I have offered in brief 4 separate arguments asserting that Maine, not upland owners, hold title to its intertidal lands. Each argument repudiates the line of cases that begin with Storer, go through Lappish, Barrows, Bell 1, and Bell 2, and Ross. Count 1 notes that the Storer court misquoted the colonial ordinance. Misquoted. The ordinance says upland owners shall have property to low water. In the 16th and 17th century, this connoted a license, nothing more. It did not grant title. Storer and succeeding Maine cases erroneously treated the ordinance as a grant. In short, the foundational premise for the line of cases noted beginning with Lappish is incorrect. Maine holds title to its intertidal land. Count 2 recognizes that the Revolution, the founding of the Union, ushered in a new paradigm. Intertidal land laws enacted by Spanish, English, colonial bodies became a nullity. Maine's Statehood Act noted that it was admitted into the Union on an equal footing with the original states. The majority of the original states adopted English common law.
Can I challenge you on that? The equal footing doctrine, as Justice Douglas pointed out, does equal footing mean it adopts the majority of the state's practices? What if the state decided?
That seems to be what the Supreme Court has in its case law.
So they've said out loud that the equal footing means that if a majority of the original
In
colonies-
Shively, they acknowledge that Massachusetts beat a different drum, but that the majority of states had in fact obtained title. The Shively case itself involving Oregon clearly held that upon statehood, Oregon gained title to its intertidal land. A more recent case involving Montana held the same thing. Upon statehood, Montana gained title to
Now,
its...
after they became a state, the state has the power to then divest itself of title and give that aspects of its title to private property owners, correct?
Discrete parcels can be alienated by the legislature. There is a constitutional provision in Maine's Constitution dealing with separation of powers that makes clear that a judicial usage, that's what Storer created, a judicial usage. There was no legislation here that alienated the title.
Well, to be
Lappish
clear,
accepted a judicial usage, and so did all of the cases following Lappish.
to be clear, the property owner can alienate, the property can be alienated, but it may be subject to certain public use rights, correct? You're not saying that the property can't be alienated except by the legislature.
I'm not sure I understand the question, Your Honor.
No, it probably wasn't clear. You're not saying,
That means try again.
try again, all right. You're not saying that that the property can't be alienated just because the legislature doesn't pass a law. It can be alienated, but subject to whatever public use rights might exist.
Well, intertidal land cannot be alienated by the judicial branch of government according to Maine's Constitution. The language is clear. The count 3 in my brief makes the argument that the Constitution posits that the judicial branch may not inveigh upon the prerogatives of either the legislative or executive branches. The line is clearly drawn. The language in Ex parte Davis, no person or persons belonging to one of these departments shall exercise any of the powers properly belonging to either of the others. To the extent that the title to intertidal land is said to have been alienated to the upland owners by a judicial usage is facially at odds with Maine's Constitution.
And I see that the red light is on, but I think Justice Horton had a question, and
Regarding the equal footing doctrine, you made the point that Oregon and Montana elected to exercise public rights over.
There are Supreme Court cases, Your Honor, that cover Georgia and Mississippi. The Phillips Petroleum case that was decided a year before Bell II, which was ignored by the Bell II court, clearly held. I'm sorry, sir.
Maine was obviously part of Massachusetts before Maine became a state. Were any of the other states, such as Oregon, Montana, Georgia, Mississippi, parts of other states before they became states?
No, Your Honor, not to my knowledge.
I mean, the argument is that once Massachusetts had established its position regarding the intertidal zone, that carried over to Maine because Maine emerged from the state of Massachusetts.
Massachusetts, in that status, though, does not have the prerogative under the equal footing doctrine to dictate the law of the emerging state of Maine. That is not equality, and there are Supreme Court case laws that state that more bluntly than I've tried to this afternoon.
I see your time is up, but I'll give you the same prerogative I'm giving the other parties. If there's something that you wanted to say and weren't able to during our questioning, I'll give you another 30 seconds or so if you want to wrap up.
I would simply say, beyond the 4 arguments I've offered in brief that assert ownership, if one or the other or the 4 arguments in combination do not persuade you that Maine is the owner of its intertidal lands, then I would certainly argue that the overturning of Part 2 of the Bell 2 case, which struck down the 1986 Act, which expanded public uses to include recreational usage, is out of step with Maine takings law. It's out of step with the U.S. Supreme Court's takings law. It is predicated on an error. The Bell 2 court assumed that upland owners could exclude the public, but even under the colonial ordinance, the public could not be excluded. They had fishing, fouling, and navigation rights. The 86 Act simply expanded those existing public rights to include recreational uses.
All right, thank you
Your
very
Honor.
much. And our next presenter? And would you please state your name for the record?
Yes, may it please the court, Assistant Attorney General Lauren Parker for Maine's Attorney General Aaron Fry, cross appellant.
So you have the green light instantly. Nobody gets saved time after this. So
Correct.
I'd like to, I know you spoke briefly about the Stop the Beach renourishment, but I tell you, I'm very concerned about how we can change our position, whether we agree or disagree about title. Once title has been declared in a case like Bell 2, how does Stop the Beach not tell us that we can't change it without affecting a taking?
So I think there's two separate questions there. The impact of Stop the Beach renourishment on the fee question, so
Yes.
fee ownership, yes, and as compared with the scope of the public trust doctrine.
Right.
So I think the question is, would this court's decision erase an existing property right? And we have situations where, for example, OA 2012 has a judgment that say they own fee title to the low water mark. We also have a landscape, as Justice Douglas pointed out, where we adjudicate fee title on a property by property basis as opposed to sort of a sweeping all intertidal land at once. So I think the court is right to be concerned with a decision that would declare that all fee title, that fee title to intertidal land is owned by the state, when it's already declared in other instances that entities other than the state, like the town in Goose Rocks Beach or OA 2012, own to the low water mark.
Yeah, it would wipe all those out, right, if we take the plaintiff's position.
I think that it likely would, but the same concern doesn't present itself with respect to the common law public trust doctrine, because there you're asking, has it erased an established property right? So if you start from the standpoint of the intertidal land we know it's owned in certain instances by certain entities or presumed to be owned by private individuals. That ownership, regardless of who owns it, has always been subject to the common law public trust doctrine. So it is, the common law public trust doctrine are reserved rights. So when individuals, so the Maine's common law evolved to say that intertidal land in Maine is susceptible to private ownership, but always subject to the scope of the public trust doctrine. And so if this court were to author an opinion, which it should, that says the public trust doctrine in Maine includes walking, it's merely just delineating the existing limitations on
But in Bell,
title.
they said it didn't include recreational walking and it's like an easement, fish fouling and navigating. So once Bell has said the easement doesn't include this, doesn't Stop the Beach say you can't change your mind without affecting? Now it's not maybe a big taking because you're only expanding you're only trying to expand the use a little, but it's still changing ownership, usage, rights to include. Why isn't that a taking when you change what Bell said?
I think so. Two things in there. While the court has denominated the common law public trust doctrine as an easement, I think for sort of ease of reference, it is not an easement, and I think that is a critical point. Easement rights are acquired and passed along. Public trust rights are reserved. They were never handed out of the public domain. And because this is a function of the common law, which is adaptable, it can't be fully delineated and sort of frozen in time. And so Bell 2, the question before the court was there a general recreational easement in 1989? And this court decided, no, there's not. But here we have the narrow issue of what about just walking? And the court, when in 1989, Bell 2, was looking at walking as just an example of an entire universe of recreational rights.
What about we've said a number of times that beaches were used as highways in the colonial era. And there's recreational walking, and then there's what might be called purposeful walking, meaning walking to a destination. And we've talked in various cases about the right to pass over the intertidal zone to go to other people's property. Do we need to rely on the public trust doctrine in order to establish the right to pass over, not recreationally necessarily, but to walk along the beach to get from one place to another?
So I think, to take a sort of very narrow view, if the court felt that it was limited to fishing, fouling, and navigation only, I think because walking is, point-to-point movement, that it would be considered navigation as we understand that term. But I do think the court should look at this through the lens of the adaptable, evolving common law public trust doctrine.
And I see your time. I'm sorry, did you wish to inquire?
I do, yes. So that would be more or less the McGarvey approach, and which Ross also employed sort of in tandem with the more traditional approach. But my question is, based on Bell and all of our other precedent, the public use rights that we have recognized really reside in fishing, fouling, or navigating, don't they? I mean, even the Crown's rights at common law, the jus publicum under common law was limited to fishing and navigation. So I know you're advocating for a more generous and perhaps broader view, but is that something you think we have authority to just, well, we'd have to overrule Bell, wouldn't we? Bell said recreational walking was not included in those traditional rights.
I don't agree that you have to overrule Bell 2 to get there. I think, I think that Bell 2 was wrong in that regard? Yes, but that was a moment in time. That was what is the scope of the public trust doctrine in 1989. And I think with respect to the terms that appear in the colonial ordinance that we're so used to, fishing, fouling, and navigation, I think that those are terms that, those were the focus
So we
of the
could
activities.
so you're saying no stop the beach problem if suddenly we decided that fish fouling and navigating included walking, lying around, rolling a beach, absolutely everything? That's how we get around stop the beach, by just saying fish fouling and navigating means everything you want to do on a beach?
I think that is not the best approach. That's why I think the best approach would be adopting the test that was modeled in Ross and exemplified in the Bell 2 dissent and the McGarvey concurrence of fishing, fouling, and navigation readily construed as compared with broadly construed. And then if not one of those three things, does the use or activity strike a reasonable balance between private rights and public rights?
I see your time is up, and I know Justice Horton has at least one last question.
As I sit here, I'm just wondering, the one solution to this hair-splitting problem about what was contemplated by the colonial ordinance and what the public trust document means is for the state to take the property. Are you aware of any movement in that direction?
I'm not aware of any movement in that direction, and I don't think that the state should have to take for the public rights that
What
the
it
public
already
already
owns,
has.
as you're saying, sure.
Yes.
Okay, thank you.
May I have my wish list?
It's the rule of the day.
Thank you, Your
In all,
Honor.
in all seriousness, this is a conversation that should not be artificially truncated. So if there's something that you wanted to say, unable to say because of the questioning, and you can say it briefly, please go right ahead.
We'll be brief. We would ask that the court's opinion on this matter clarify that the public trust rights in intertidal land are not technically an easement, acknowledge, as does 12 MRS 571, that the state is a trustee of public trust rights, and rehabilitate in part the Public Trust and Intertidal Lands Act, because if you look carefully at that, most of that is not unconstitutional, even if you are measuring it against Bell.
Thank you.
Thank you, Your Honor.
All right, and I guess we are shifting gears here, and Attorney Smith will be next on the lineup. Yes.
Good morning.
And would you please state your name for the record?
My name is Gordon Smith. I represent the 7 individuals who are the rockweed defendants in this matter. That is, they were sued either because they contacted Marine Patrol regarding the harvest of rockweed on their property without their permission, or in the case of the defendant Robin Seeley, she was sued solely because she's a rockweed conservation activist or advocate rather. And in both of those cases, with all of the rockweed defendants, they were acting in reliance on this court's unanimous decision from 2019 in Ross v. Acadian Sea Plants that the owner of the intertidal land has the right to either permit or deny others from harvesting rockweed on their property. Most of the intertidal landowners, most of the rockweed defendants were dismissed, or the claims against the rockweed defendants were dismissed under the state's anti-SLAPP statute. Now, the court properly made that dismissal because the rockweed defendants were sued based on their petitioning activity, either contacting Marine Patrol or by merely trying to publicize, in the case of Robin Seeley, the Ross holding that landowners had the right to permit or deny rockweed harvest. Now, we are cross-appealing because the Superior Court committed legal error when it denied our request for attorney's fees under the statute. The legal error was that the Superior Court imposed a malintent test. The Superior Court found that attorney's fees should not be awarded because it found that the plaintiffs had not initiated their suit with quote-unquote malintent. Now, there's no malintent standard or any concept related to malintent in the anti-SLAPP statute or in the cases interpreting it when the court has looked at what test to apply when determining attorney's fees. And what the court...
Anti-SLAPP... What's that? Oh, I'm sorry.
Yep.
Well, as the no, go ahead. This is protected time.
Thank you, Your Honor. The court has said the test for whether or not attorney's fees should be awarded is whether they would further the purposes of the statute, and the court has said the purposes of the anti-SLAPP statute are twofold. One, obviously to safeguard First Amendment petitioning, and two, to deter meritless litigation. And in this case, both of those factors are present. As the Superior Court found, the rockweed defendants were identified and sued based on their petitioning activity. And the two claims against the rockweed defendants, one, ownership of that apply to the rockweed defendants, ownership of intertidal land being held by the state, and that Ross should be overturned, are without merit. On the title issue, you have centuries of unbroken precedent without any dissent indicating that that intertidal land is subject to private ownership. And in Ross, you have all 7 justices applying the broadest test possible, the common law balancing test, and finding that under that test...
Let's assume that the calls to the Marine Patrol authorities or calls to law enforcement constitute petitioning activity. Were your clients sued because of their petition activity? In other words, were they sued for making groundless calls to Marine Patrol? I thought the claims against your client had to do with title and access to rockweed rather than...
The only landowners that were sued were the landowners that contacted Marine Patrol.
But that doesn't mean they were sued for contacting the police.
There was no other reason that was identified for them to be...
Their position that the rockweed harvesters can't harvest rockweed was why they were sued, as I
which is
understand it.
completely inconsistent with settled unanimous law court precedent in Ross.
Well, are you saying when anybody calls the police to enforce the law, that's petitioning activity?
Yes, it is. It is petitioning activity.
So if I call the police because you're trespassing on my property, and I bring a declaratory judgment action because, to establish title, I get hit with anti-SLAPP attorney's fees?
Because you filed a lawsuit?
Because I called the police to have you removed from what I claim is my property?
The the court has held that petitioning activity includes calling law enforcement. The
Well,
court has,
true.
that's a uncontroverted holding from the law court. So whether or not, so it's prima facie petitioning activity. Now,
And I see your time is up. You actually anticipated my early question, so that's covered. But if there's something that you wanted to say that you weren't able to say, and you can say something, you can say it briefly, you're welcome to have some additional time here.
thank you. I would just say that the Rockweed defendants' inclusion in this litigation should be viewed as separate from the questions the questions of recreational use that the court has signaled it is interested in revisiting. In Ross, it signaled that, but they should not be viewed as legitimate defendants who have to protect themselves and from suit or defend themselves in suit because of the plaintiff's unwillingness to accept a unanimous 5-year-old law court decision.
And I'll ask you a question. In your opinion, was the lawsuit frivolous?
It certainly borders on frivolous, yes, based on settled existing precedent.
Thank you.
Thank you.
Good morning, Your Honors.
Would you state your name, please?
Sure. May it please the court, my name's Emily R. Visu. I represent Ocean 503. The Moody Beach defendants have divvied up topics,
Oh, okay.
if that's if
All right.
that's allowed.
What's your topic?
I'm focusing on the issues of standing and justiciability. So any decision issued by this court impacting Maine's 3,000 miles of coastline cannot be supported by the lack of justiciable controversy now before it. First, plaintiffs lack standing with respect to count 4 specifically because to date this court has never recognized standing of an individual as a plaintiff to assert public trust rights in the intertidal zone against an upland owner. Second, plaintiffs have not met their burden of establishing that a justiciable controversy exists, and this court's review of the legal correctness of defendants' action or inaction will not make any real-world difference to the plaintiffs. With respect to the issue of standing on count 4 specifically, this is a different scenario than many of the intertidal decisions that have come before. In those previous cases, they've been in the context of a quiet title action or a trespass action that was asserted by the beachfront owner. And in those cases, specifically in Bell 1, this court said that it's clear that an individual can assert the public trust rights as a defense to a trespass or quiet title action. But it's an open question of whether an individual person has the ability to assert affirmatively the public trust rights in the intertidal zone. So
Are you suggesting that prerogative exists solely to the Attorney General, to the state?
yeah, it's our position that, as this court laid out in Bell 1, the Attorney General has the duty and power to initiate actions
But the
for the
exclusive
protection.
power, did we say that they have the exclusive prerogative to assert the public rights?
Yes, we believe that the Attorney General should be the one who is asserting these claims on behalf of the public due to the nature of those rights. But setting that aside, if in the instance that the Attorney General is disabled from doing so because of, a conflict of interest or something, then perhaps an individual could do so, but it would have to be an individual who's an actual substantial user and with a direct injury. I think in this case, some of these plaintiffs, 3 of them have been on, Ocean 503's property specifically, but they haven't been injured.
Does the rockweed harvester have a particularized injury here?
Not with respect to the Moody Beach defendants. I can't speak to
Okay.
others.
Fair enough.
The Attorney General is a party in interest to this proceeding. They are making an argument. Your position is in favor of public trust rights, but your position is if the individual plaintiffs don't have standing, then the Attorney General is disabled in this case from asserting that position?
Not necessarily that the Attorney General is disabled in this case, but the Attorney General did not file an answer to the complaint. The Attorney General has not asserted any cross claims at the lower level, and so they participated in briefing to an extent, but they didn't actually file any sort of response. And they didn't formally, at least, assert claims. And I think it's interesting as well that in this particular case, the Attorney General has chosen not to pursue the title claims and has very narrowly tailored count 4 to just walking, as opposed to, the entirety of general recreational rights that plaintiffs are seeking.
And your clients object to a just walking use right?
So our clients have never objected to walking in the past. They essentially were chosen because they, as many Moody Beach property owners, have signs on their property indicating that it's a private beach. And then during discovery, we learned that they were also chosen because their property is along a right-of-way, and the size of their house is substantial, which plaintiff said indicates that they're not there on a shoestring.
So is it your position, or your client's position, that they do not object to the public walking along the intertidal zone in front of, on their particular properties?
Yeah, they have never objected in the past, but I think the question of whether they personally object is they're cognizant of the fact that any decision here is going to have wide-reaching implications, and so I think understandably they're reluctant to take a position that differs from current case law.
But as far as their property is concerned, they're not objecting?
They have never objected in the past, no.
The plaintiffs, if I may,
Yes, and then Justice Connors.
the plaintiffs
Light.
seem to interpret the sign
Microphone.
as limiting, as prohibiting walking. Should the sign say no loitering, but walking is okay?
Well, I think this was actually explored during deposition of our client, Ocean 503, and they talked about the fact that no loitering, implies that you're just kind of standing there for an extended period of time, not really doing anything. And so, I think that would exclude walking from that definition.
Just a fact check. You said that 3 of the plaintiffs came onto the property of your defendants, correct?
Yeah, yes. So 3 of the plaintiffs have definitively come onto the Ocean 503 property.
And were they chased off? What happened?
No, ma'am. They have never interacted with our clients, to the best of my knowledge. There's been no confrontation, no objection, no action at all.
I see your time is up, but following the ad hoc process we're following, if there's something that you wanted to say, weren't able to say, if you can summarize that briefly, you're welcome to do so.
Thank you. Yes, I just want to reiterate again, given the weight of this court's decision and its potential impact on the entire coastline of the state of Maine, I think this court should give significant consideration to the standing issues and the lack of justiciability here. So I thank you for your time.
Thank you.
Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you. Thank you.
Good morning, Your Honors. Chris Keyser for Judy's Moody, and I'm going to focus on the title and use issues. And in view of that, I do want to focus mostly on the implications of what appellants are asking this court to do here. They ask this court essentially to transform, or to give the legislature the power to transform, what has always been or recognized as private property into public property. And they ask this court to do so without providing just compensation, as the constitutions of the United States and Maine require. As we've already discussed, private ownership of intertidal land in Maine is deeply rooted. It's been part of the common law in the state since before statehood. And while it's true that the law has always recognized some public rights in this area dating back to the colonial ordinance, this court has always noted, even it is incorrect to say that Bell II was the first time that the court limited these public rights. There are several 19th century cases, such as Deering and Marshall, where the court discussed that the rights of fishing and navigation were the ones that were specifically protected for public use. And just because that Bell II was the first case where actually the court had to deal with a larger claim due to the 1986 act, that was the first time that the court had to address the limits of fishing, fouling, and navigation. But it was not the first time.
I'd like to ask you a question about the intersection between this case, which focuses on the public rights conferred by the colonial ordinance and also the public trust doctrine, and the Almeida case, where we decided that in order to claim title to the intertidal zone, a beachfront property owner had to prove that their chain of title included title to low water. Has that been established for any of the appellees in this case? And if not, do they even have standing to assert the colonial ordinance?
Your Honor, in Bell II itself, this court actually held that title to Moody Beach for the Moody Beach owners goes down to the low water mark. So as for Moody Beach specifically, there's no dispute that title goes down to the low water mark here. So in my client and the other Moody defendants, they own title down to the low water mark under this court's current law.
Do you have any thoughts about others, though? People who aren't on Moody Beach and therefore aren't benefited by the Bell II judgment?
I think that's one of the problems with this court making a sweeping decision in this case when there's only 3 beach defendants here, because if this court were to say overrule Bell and overrule Lappish and say that the state holds title up to the high water mark, that would affect thousands of property owners across the state who aren't here to defend their rights, and it would do so without compensation. There would be no method in which this court actually, in the context of this case where we only have 3 Moody defendants here, to determine what kind of compensation should be given to those people who have these rights that have been recognized.
So if there's only one person literally left standing, the decision in the case would affect the entire coastline of Maine.
And yes, Your Honor, and that's the reason why, one of the reasons why this case is a poor vehicle to even to address, even if I agreed that Bell II was wrong, which I don't. This case would be
just about to ask you. We've heard arguments here today that Bell II just wrong, throw it away, throw it out. Can we do that? Should we do that?
No, you shouldn't do that. I think the biggest thing I would say is that Bell II doesn't stand on its own. Bell II was a case that simply synthesized the existing common law in this state and in Massachusetts going back to Storer. So to toss aside Bell II would inevitably affect a taking, because there are deeply rooted rights here, private title down to the low water mark, that are subject only to the limitations that the common law has recognized, which are fishing.
Did Bell II announce what the common law is?
Your Honor, yes. Bell II synthesized the prior case law, including cases like Deering, Marshall, and Andrews, and it declared that fishing, fouling, and navigation, a liberal construction of those were that was the limit of, and this is consistent with Massachusetts in the opinion of the justices, advisory opinion that the Massachusetts Supreme Judicial Court issued in 1974. So when my friend on the other side said that there were no cases that said that a legislative conveyance in the public trust affected a taking, that's exactly what the Massachusetts Supreme Judicial Court found. And I realize it was
I think Justice Douglas has a question for you.
You may have just answered it. My question was, the plaintiffs aren't, at least the Attorney General's office is not asking for such a drastic remedy. They're not asking to disentitle anyone. They're just asking to expand a little bit the current public use rights. You view that as a taking?
Yes, Your Honor. The problem is that in Bell 2, the court said recreational walking.
I understand that. But if that were to be changed, if the court were to sort of change direction on that, is it your position that that's a taking under Stop the Beach or any other provision?
Yes, Your Honor. So actually, just this past term in Sheets versus El Dorado County, the United States Supreme Court adopted the plurality opinion in Stop the Beach and made it clear that any branch of government can affect a taking. And so when a judicial decision does expand public rights at the expense of previously recognized private rights, that would be a taking, and the amount of the taking that just goes to the amount of compensation. So, for instance, in the U.S. Supreme Court's case of Cedar Point in 2021, in that case it was just the right to exclude for 3 hours per day, 120 days per year, and I believe at oral argument in that case, Justice Barrett noted that the potential compensation might be something like $50. But the court still held that it was a taking because the scope of it, whether it's just adding walking, that might go to the compensation, but it doesn't go to the fact that there's an established right here that were the court to overrule Bell 2 on this ground would take that established right away without compensation.
So if Bell 2 were not overruled and were held, the legislature would have the option to expand the public use rights by eminent domain.
That's correct. There is a political solution here. I believe that was mentioned earlier as well. The state or the town of Wells could buy the land or condemn it through eminent domain.
In fact, some beach communities have done that.
And that's exactly what has happened in other towns. And so that's the solution, is that if the state wants there to be, or if the town of Wells wants there to be a public beach along Moody Beach, they can have that. They just have to pay for it under eminent domain. And that's the whole purpose of the Fifth Amendment.
All right. Do you have any, we're well into overtime, do you have any last words you wish to say?
I would simply urge this court to stick with the course that it's been on since Lappish, and recognize that these private rights are deeply rooted, and that to alter them at this time without compensating the landowners would be a taking in violation of the Fifth Amendment. Thank you.
Thank you.
Good afternoon, members of the court. I'm David Silk. I'm here with Sidney Thaxter, who was from Curtis Thaxter. He was lead counsel in Bell 1 and Bell 2. And I covered a lot of ground in my brief, why we don't believe there's a case or controversy before the court, lack of standing. The same signs that they point to as creating a chilling impact were the same signs that were the subject of the trial testimony in Bell 2. And without waiving the arguments on our brief, I just want to take a step back and talk a little bit about the issue whether this should be viewed as an easement, which is what both the Bell 1 and Bell 2 court said it should be viewed as. And for the most part, a majority of the justices, all 18 that have heard this case, counting the justices on Bell 2, majority of them viewed this as an easement versus viewing it under the lens of somehow it's a public trust where the fee is owned by the state and held in trust for the benefit of the people. The dichotomy, the easement language was not codified, but was examined in Bell 1. And the reason for that was it was a quiet title action. And in Bell 1, the state took the position in the town that the plaintiffs couldn't even seek a quiet title because the state held the public rights and there was sovereign immunity. And if you read Bell 1, the majority, the unanimous opinion of the court, they went back in time, looked at the cases and said, we viewed this as an easement. The state doesn't own the fee to the intertidal zone. It's assuming you have a conveyance that gets you to the ocean. Historically, for 250 years, it's private property. And we've always viewed the rights reserved to the public as easements. And they cited the Manchester City Augusta case and other cases that say it's not uncommon where public easements are granted for the benefit of the public over private property. So that was the paradigm in Bell 1. Goes to trial, 16-day trial, 70 witnesses. Justice Broderick heard the case. And he viewed it as the instructions from the law court is examine this as you would in the context of a public easement. He heard the case, heard all the witnesses, and one thing I just want to share, he issued a 58-page decision. Again, this is a quiet title action, quiet title. Notice was given to the world, publication in the newspaper, guardians ad litem were appointed for people who couldn't appear or didn't appear. He said the public's need for recreation is important, but private rights are also important. Private property rights should be predictable and not subject to dramatic transformation by the courts when there is an absence of the traditional types of evidence that would normally justify the evolution of a common law doctrine. And that's the trial judge hearing this in the context of expanding whether liberally construed the rights reserved under the easement should include public recreational rights. You then have read Bell 2. I don't need to go there. You've read the concurrences and the subsequent cases. But I thought it'd be helpful for the court to understand how it came to be. The court examined this. Again, they cited cases where they've done so in the past where they used the word easement, so it wasn't like they're inventing it out of whole cloth. But to overrule Bell 2, you would effectively have to overrule Bell 1.
I don't disagree with your characterization of Bell 1 at all, but if it was an easement case and if the court's decision depended on the evidence presented is, what's the res judicata effect of that decision?
I'm not sure
to what extent is the outcome of a quiet title action binding on parties to an easement beyond the parties to the litigation?
In terms of this case?
At all, in general?
Well, at the end of the day, I think that, again, you've got a whole host of different judicial opinions by your colleagues going, that's why I said there are 18 justices that have heard this. I can't articulate any better than the views of those justices who believe Bell 2 should stand.
So if there had been a private litigation between private parties, obviously that's res judicata regarding those parties, but if the court makes a broad announcement of law that controls the decision there, is that res judicata for the entire world? Well, that broad statement of law.
Yeah. I mean, I think that was articulated in Bell 1 in terms of the nature of the scope of the easement that was reserved.
Okay. Yep, go.
So the state was saying that at times it's been treated like an easement, but because it relates to the public trust, there should be more room for the state to allow it to evolve. What's your response to that?
Well, again, my client stands in the position of res judicata in a quiet title action, and that position of the state would render res judicata meaningless because the state's position is that in 1989, the law court couldn't decide what would be their decision in 2024. They could only decide what their decision is as of 1989. And again, Chief Justice McHugh emphasized that the rights reserved should be liberally construed, sympathetically construed. There was an element clearly recognized by the majority in Bell 2 that this was an evolutionary process. It wasn't stuck in stone. And the question is, how far do you go? Where do you go? And again, that's the predicament the court addressed in Bell 2 with the concurrent, I mean, the dissent and the majority. I can't, my view is, I think Justice Levy's concurrence and Justice Broderick's authorization is that, you know, we're not alone. Massachusetts has a tradition. Massachusetts' tradition is firm, that the public rights that reserved under the ordinance of what had been articulated in Bell 2.
I'll just
And
step
so-
in for a second and ask if colleagues have.
A quick question, if I might. Have your clients ever objected to anyone walking across the beach?
And again, in this record, in Bell 2, in Almadea, and in this record, there's never been an instant, again, we have to differentiate between the dry sand and wet sand, Your Honor.
I'm talking about the intertidal
But I know,
zone, yes.
but sometimes it gets confusing because usually there's a seawall, dry sand and wet sand. But on the wet sand, and I'll tell you why there's never been an objection. Most property owners own 50 feet of wet sand. I mean, there was adjudication in Bell 2, quiet title judgment. My client owns to the low water mark, owns. I mean, there's an adjudication, it's of record. But as soon as my client leaves the 50-foot and walks to the left and walks down someone else's intertidal zone, everyone recognizes that it's in their interest to give implied permission for everyone to walk up and down the beach. And so thousands and thousands every day, which is what Chief Justice McCusick recognized in Bell 2, was mentioned in Almadea, uninterrupted, people walk the beach. It's a main tradition. It's a main allowance. And I understand the pro se DeLogue's issue is with the court's jurisprudence. He's never, ever been interfered with in any way walking up and down the beach. It's like hunting on posted land.
Justice Douglas, did you have any further follow-up? All right. Thank you very much. Okay, we're back to rebuttal.
Yes.
And I'm not sure if I'll continue the ad hoc last words thing, so if there's something you want to get your last words in, you'd want to do it within your allotted time.
Okay. Thank you, Your Honor. I just want to first start with stop the beach nourishment because I think the takings question is a fair question. Look at the cases. In all of the cases that are cited where there's been a taking, the owner had a fee simple absolute ownership, no easement, no public trust right. That's why it's distinguishable. Look at Phillips Petroleum. The state has the authority to define its public trust law. What can that mean if any time the state defines its public trust law, it commits a taking? And the more recent case than Stop the Beach is Cedar Point. In Cedar Point, decided in 2021, the court states very clearly that property open to the public is readily distinguishable from regulations granting a right to invade property close to the public. The intertitle is open to the public. It's readily distinguishable from private property that is within the takings jurisprudence.
Going once, going twice?
There don't seem to be any, doesn't seem to be any conflict here, though, in the sense that I haven't heard from any of the property owners that there's an objection to the public walking through the intertidal zone.
The signage and the chilling effect is, it overstates their rights. That misstates, even under Bell, private beach, no loitering, I think is as construed in the summary judgment record, is a misstatement, an overstatement of their rights. And there's enough for a justiciable controversy.
How is it an overstatement if they own it? I mean, you don't like that they owned it, but I mean, is that enough to give you standing? You just don't like the fact that they say they own it?
How would a reasonable person interpret a sign that says private beach?
It says no loitering, so doesn't that mean if you don't loiter, okay, and they've never stopped you? So how is there a real case or controversy?
Some people might view fishing as loitering.
Right. Well, what is loitering? Is it loitering by the sign? How long do I have to loiter? If walking's okay, how can I remain? There is enough to get into court on this controversy because of, and look at the cases on standing and justiciable controversies. It's whether it has an impact on the plaintiff that's sufficient to create an injury. And we've established a record here on summary judgment for that. If I could go back to the question around whether there was ever a state that became a state out of another's common law, that would be Pollard versus Hagan, where Alabama came out of Georgia. We cite that in our briefing.
But with respect to that doctrine,
Sure.
precisely what is the holding in Shively? What is it that any new state coming into the Union comes in on equal footing with the majority of other states?
So it comes in on equal footing, which means title ownership of intertidal land.
But that wasn't the state of the law in Massachusetts.
Right, well, but Massachusetts law, for Massachusetts law to control Maine would be that Maine is unequal. It would come into the Union on unequal footing because we happen to be related to Massachusetts, which is contrary to federal law.
So your argument is Maine had to come in on equal footing with the majority of other states.
Every state that was admitted to the Union subsequent to the original 13 took title to intertidal land, period. That's what the Supreme Court has said in every case. And on the anti-SLAPP, the standard is whether the claims are based on the petitioning activity. So there's no question that a phone call to the police has been held to be petitioning activity, but the claims are not based on that petitioning activity. There is a controversy with respect to seaweed that I think has been established in this record.
You have 45 seconds.
The upland owners, they're not objecting to the walking or to the uses by the plaintiffs, but what they want is the right to object. They want the right to post the sign. They want the right to claim the ability to do so. And that is enough to create a controversy because there's a disagreement about the parties' respective rights. Okay.
All right, you've had the last word.
Thank you.
For your side.
Thank you, Justice. We very much appreciate the extended time. I appreciate the
Okay,
opportunity.
thank you.
Thank you, Gordon Smith again. Following up on that discussion that we just had with Justice Douglas, asking what does the equal footing doctrine mean when some of the original states had already conveyed out their intertidal land. And it doesn't mean, the equal footing doctrine does not say, and the Supreme Court has not said, that it means that all states gain title, whatever the state of the title was before statehood, when they enter into become a state, that all of a sudden the records are wiped clear and the state owns all the intertidal land. What the equal footing doctrine says is that the newly admitted states have the same rights as the original states. And that right includes the right to convey that land, among other rights. And it's instructive to read from Phillips Petroleum, and quoting Shively v. Bowlby, it says, Phillips Petroleum's quoting Shively v. Bowlby and says, "There is no universal and uniform law upon the subject, but each state has dealt with the lands under the tidewaters within its borders according to its own views of justice and policy. Many coastal states, as a matter of state law, granted all or a portion of their tidelands to adjacent upland property owners long ago. Our decision today does nothing to change ownership rights in states which previously relinquished a public trust claim to tidelands such as those at issue here." So the Supreme Court has recognized that there is no universal vesting of title in the state. The states have the authority to determine what rights they want to convey or retain in the intertidal. And Maine, in the adoption of its constitution, said, in Article 10, said, we are adopting the common law of Massachusetts, so as long as it's not repugnant to some other part of our constitution. So that was a foundational act of the Maine, the people of Maine in adopting that constitution. That was an affirmative act in which they adopted Massachusetts.
Should the Maine legislature have taken that step instead of the courts? In other words,
I don't think the courts did.
the plaintiffs are making a separation of powers argument, I believe, or at least they, at one point.
Yeah, no, it's not, the courts have not, the courts are interpreting, the colonial ordinance of 1647. They're also interpreting the common law of Massachusetts. They're interpreting the Constitution of Maine and subsequent case law that has unanimously held that in Massachusetts and in Maine, the states have decided, either through the colonial ordinance and usage or through the adoption of the Maine Constitution, that intertidal land in these states, among others, by the way, is susceptible to private ownership. We heard that, that somehow the law court misquoted, or rather, it wasn't the main court, it was the Massachusetts Supreme Judicial Court in Storer misquoted the colonial ordinance by saying that property that the upland owner holds down to the low water. That wasn't a quote. The court in Storer was not quoting the colonial ordinance. It was interpreting the colonial ordinance. What does that word propriety mean? And in the early 1800s, closer in time to when the colonial ordinance was adopted, that was the understanding of the court at that time, is when that was a grant of property or propriety, that meant that you hold down to the low water. We heard about the chilling effect that the signs supposedly have on the people who walk on Moody Beach. Taking that into the context of the anti-SLAPP dismissal, the question was this petitioning activity, and if so, are the plaintiff's claims based on that petitioning activity? We also have to view this in terms of the chilling effect that the plaintiff's suit against the Rockweed defendants for simply following the court's guidance in Ross will have on those defendants and other landowners, where the only landowners that were sued were the ones that contacted contacted Marine Patrol, or in the case of Robin Seeley, there are no allegations against her other than she's publicizing the rights that landowners have under Ross.
Thank you.
Thank you very much.
All right, that concludes our oral arguments in these matters. The court thanks counsel for your thoughtful arguments and your excellent briefs. You all did a terrific job in briefing these complex issues. We appreciate it. Rest assured, we've read them in detail. We'll read them again. As clear as the case may have very consequential results. No one knows at this point. So we'll take the matter under advisement, issue a decision in due course, and for the students and anybody else who may be wondering, what that means is that the 6 of us will meet behind closed doors and debate it amongst ourselves. If we all agree on a single result for each of the varying claims, we would issue what's called a unanimous opinion, which I don't think we've done yet in this proceedings. Have we done that? I guess the original Bell one was unanimous. If we don't, justices have the right to issue a dissent saying, well, I see it a little bit differently. But we'll have to wait till we issue the decision in due course. Again, many thanks to counsel for your excellent materials in this. And this court stands in recess until our next term.